everybody, welcome back to the channel. In today's video, we will be reviewing trial day 25 with Jessica Hyde and Joseph Paul. Jessica Hyde is a digital forensic examiner. She did an analysis on the copy of the data from Jennifer McCabe's phone. She spent about an hour explaining how she does these searches. And essentially what it came down to is whenever you open a tab to search for something on Safari or Google, when you do the search, let's say you don't close it, and let's say you just moved that tab to the back, and then you checked your calendar on your phone or something, and then you went back to that tab, did some more searches, and this time you actually closed it. You hit the X and closed that tab. It will create a timestamp when you make that closure. However, I put timestamp in quotes because timestamps don't necessarily reflect the time you do a search. It just creates the timestamp once you close it. She said that to determine exactly when Jennifer McCabe did that search, Long to Die in the Cold, she couldn't give an accurate time of when it was searched because Trooper Tully only had her looking at the search history and not phone call logs. So if she would have had access to the phone call log, she could have compared that data with the searches and gave a more accurate description or estimate of when those searches were actually made. Next on the stand is Joseph Paul, and he is the trooper for the State Police of Massachusetts. He used a drone to create a photo of the entire scene there at 34 Fairview and marked where each piece of evidence was found. And then Lowley went into bloody detail about Joseph's knowledge about cars and crashes and how airbags worked. If there were airbags on a vehicle, are there airbags on the outside of a vehicle? Does it protect a person who's been hit who's on the outside of the vehicle? If Karen's vehicle had any factory recalls. He also explained that it's not uncommon for a shoe to fly off of a person if they've been hit by a vehicle, and further stated that anything that's not tied onto the body will fly off of the person in the direction they're ejected because all the motion is being pushed in that direction. Now, the only problem I have with that is how John's phone ended up behind his back between his shoulders. And I guess it's possible if John had his phone in his back pocket. I'm not sure where he carried his phone, but let's just say it was in his back pocket. Then as he flew, it could come out. However, let's take a look how that might work. Of course, this is just my own analyzation, so don't take it as scientific fact or proof. I just want to give an idea of what that would look like. So here is some of my son's toys. And so we're going to say that John had his phone in his back pocket. If this is the house here at 34 Fairview, so if he was hit and somehow ended up upside down sliding, then I could see the cell phone coming out of his pocket. He also went on to explain that when John was hit, his body moved naturally forward, hit the vehicle, and that's how he got damages to the front of his body, and then it spun him around and then projected him. That then requires you to believe that John was hit, broke the tail light, and stayed with the vehicle long enough to cut up his body before he was ejected and sent off. So he basically did a pirouette like a ballerina and went flying. And now the speed they're claiming she was going was 24 miles an hour. He also showed a printout of the car's accelerations as well as the key cycles and the RPMs, etc. Now that's going to get a little complicated, so I'm going to do my best to simplify it the best I can to make it the most understandable. Within these printouts, it shows that Karen's vehicle had moved forward at one point. It was put into drive, moved forward, so there was acceleration, and then put into reverse and was moved backwards, and then, of course, with acceleration, and then put into drive and left. So this would account for why they're saying that Karen drove forward, backed up, then drove forward and left, according to their scenario. Let's just say she did put it in drive at this point, okay, because that's going to become a separate issue of determining when the vehicle was actually put in drive and how they determined that the vehicle was put in drive at this exact time and had acceleration at this exact time. But before we get into that, let's just say she was there, her vehicle accelerated, but you got to remember, what were the road conditions at that time? Lally has made it bloody clear that there was a blizzard that night. So the roads were slick, they're icy, wet, snowy. They're going to have all of those conditions. And I don't know if you've done any driving, but when you drive in those type of conditions, your vehicle, when you put into drive, will often accelerate a little faster before your tires get grip and pull you. So if there was an acceleration in the idle of her vehicle, that could account for it. Mr. Paul also went on to say that the angle of her steering wheel at that time is consistent with the angle one would need to hit a pedestrian. Now, to conclude that this is the only angle to hit a pedestrian is silly, because that angle could also be consistent with really anything else. Your tires spinning, you're going to have movement in your steering wheel. If you're pulling onto a road, you're going to have movement of your steering wheel. There could be multiple endless reasons why your steering wheel could be put at a certain angle. So to conclude exclusively, this is the angle you need to hit a person is silly. He also explained that when John was hit, he wasn't hit center mass. So he wasn't hit right in the middle of his body. He was hit off to the side. So he then didn't take the full impact from the car hitting him. And the reason why this was explained and talked about was because there's a math equation that can be used to explain a force of a vehicle and a projection of an object, but he didn't use that mathematical equation to try to figure out any of this. So all we have is Joseph claiming that John was hit to the side and spun off. At what rate, we don't know. We don't know if he landed or he slid or how we ended up in that spot 30 feet away. So Joseph actually categorized or described John's projection as a crash and sideswipe. So as they're claiming, Karen got mad and hit John with her car. Are we then to conclude that John just stood there and didn't get out of the way and just got hit? Or are we then supposed to conclude that John got hit as he was trying to jump out of the way? And if that was the case, he would have been hit on the left side, not the right side, and his injuries were on the right side. They also played footage of Mr. Paul testing Karen's vehicle, accelerating, decelerating, seeing how long it would take to stop, so on, just back and forth. However, my problem with that test is the weather difference. So you can't compare the vehicle's acceleration and deceleration the same when the weather conditions aren't the same. At that point, the roads were icy, they were snowy, they were slick. The vehicle is going to operate differently when you're in dry conditions or even just rainy conditions. Like, it's still going to have a different effect. So I'm not quite sure why they wanted to use his testing as evidence to prove their case, because in my opinion, it's definitely comparing apples to oranges. It was at this point that Miss Beverly sent the jurors home for the weekend because of some disputes between evidence, I would imagine, and continued without them. They went ahead and played the video footage of Karen backing up out of John's garage that morning again. And when Karen hits John's SUV, you can actually see some of the snow fall off of the window of his vehicle. He, as in Mr. Paul, Trooper Paul, was claiming that Karen's SUV was not moving fast enough to break her taillight when it contacted John's vehicle. And he went on to state that since the vehicle has a bumper, the bumper would have stopped her vehicle from making contact with John's vehicle and breaking her taillight. However, Mr. Jackson was quite upset with his conclusions and was asking him if he had done any kind of pressure testing to see what kind of pressure it would need for that particular type of plastic to be broken or what it would take to be cracked. And he said he didn't do any of those type of tests. He also didn't do any kind of tests to match up Karen's vehicle with John's vehicle to see if they could actually match and hit each other at those locations or at those spots of the vehicle without the bumper stopping the vehicles from colliding. He said no, he didn't do any kind of testing like that either. There was no testing done. What would it take for metal to put that much pressure on plastic to create that kind of crack or break in the tail light? And he didn't do any of that type of testing.
I've had pedestrian crashes that have been at a very low speed.
Okay, that wasn't my question. That wasn't quite my question.
Okay.
My question is, have you been called in to a crash involving two vehicles
Yeah.
that have made contact at about a mile an hour?
I have seen testing for vehicles at low speeds. So next time I've been called to a crash, I go to fatality crashes, but I have seen testing for vehicles at low speed impacts.
Okay. Like, how low speed?
Like just the bump.
So like this?
Yes.
Did you see any damage?
Yes. All right. Well, minimal damage.
Right. In what circumstances? Minimal damage, like, I don't know, like a cracked taillight.
No, like just a little bit of rub off on the paint.
Right. Or you might see nothing, right?
Yes.
You've certainly seen circumstances in which two cars come in contact and there's absolutely no physical damage to either car, nothing observable, right?
Have I gone to crashes that I've seen no physical damage on a car?
Or just in common sense, just everyday life, where one car backs into another car at the Jiffy Lube, makes contact, and drives away, and there's no damage.
Not normally. It's usually something with car and car impacts.
Like, what's the something?
A crack or a paint, something, chip, scratches.
Right.
Yeah.
So if you put a piece of metal in that scenario, if you put a piece of metal, steel, right,
Uh-huh.
against a piece of plastic, which one do you think is going to give way first?
You'll still see some damage to both vehicles at a speed.
Which one would give way first?
Between metal, depends what speeds. And what we're talking about, you're just saying plastic and metal. You're giving a pretty general, broad plastic and metal
Triple Paul,
analysis here.
you got to agree with me that there are circumstances in which low speed, very, very low speed contact between two cars can certainly leave damage on one and not damage on the other, damage on both, or no damage on either one. Observe.
Yes, I just said in a situation where the scratch on the side of her car had a scratch mark and his doesn't appear to have anything.
Mr. Lally asked you a question a few minutes ago, and you indicated that something might, like a taillight, might actually crack, correct? At a low speed impact.
A taillight might crack on a low speed impact?
Correct.
Yeah, it might crack. And I watched the first time on court TV, so.
So who on court TV during this trial?
Like,
Prior hearing.
no, when it was on TV at some point.
When did you and Mr. Lally have a discussion about you testifying about this video?
That was a couple weeks ago?
I'm sorry, I couldn't understand.
A couple of weeks ago?
What's a couple of weeks ago? Is it 10 days ago?
2 weeks ago? 2 weeks ago? 2 weeks ago? Two.
Where did you two meet?
At the DA's office.
Was that at your request or was that at Mr. Lally's request?
It was a pre-conference hearing, or pre-trial hearing.
Right. Well,
Or pre-trial conference, sorry.
Done?
Yep. Yes.
We're talking over each other. We're trying not to talk over each other.
I'm trying not either.
Let's both try hard.
Okay.
Who set up the meeting?
For my pre-trial,
Yes.
okay. Adam Lally.
Who was at the meeting?
Right, sitting right here, Lieutenant Tully.
Lieutenant Tully, you, Adam Lally, Laura McLaughlin. I'm guessing Ms. Gilman was not there.
She was not there, correct?
Did Mr. Lally show you this video at that meeting?
Yes.
Did he tell you that he intended to ask you some questions about this video at that meeting?
Yes.
Did he ask you whether or not you could render an opinion as to whether or not the impact that you saw or lack thereof, whatever the case may be, was consistent or inconsistent with damage to the taillight?
Yes.
Did you tell him that you would give him such opinion if called upon at trial?
Yes.
Did anybody take any notes?
I don't know.
Were you taking notes?
Yes.
Where are those notes, Trooper Paul?
I think I just, well, no, it's not on this specifically, but just, make sure I had, my everything checks and balance. And for what I want to talk about, what we're going to talk about.
Make sure you had
My
what?
checks and balances, sorry.
Checks and balances.
Just make sure I'm more on the same page of what we understand, what what's going on in the trial.
You want to make sure that you're on the same page with Mrs. Lally about what's going on in the trial.
Yes.
All right. Did Mr. Lally take notes?
I have no idea.
You were watching him. I mean, was he writing something down?
I wasn't paying attention to his note taking.
Ms. McLaughlin was there. Was she taking notes?
I don't know.
You didn't see her either?
I don't know if there were people who were taking notes, writing stuff down, or what they're writing stuff down in relation to our little conference.
So you're moving to exclude this. I'll hear you, Mr. Jackson.
Your Honor, it's very clear that this is a blatant security violation. Commonwealth has at least the obligation to provide us with any new opinions that any expert's going to testify to on direct examination. They've known about this witness for not months, for a year, for a couple of years. They've known exactly what this witness has memorialized in his official report. They knew that the only thing that we had was the official report. They met with him 2 weeks ago. This has become a pattern of conduct by the Commonwealth over and over and over. We're finding these witnesses getting on the stand, finding out that there's been a sort of preemptive strike in some sort of a prep interview where they're coming up with new opinions, new conclusions, new facts. It happened with Jennifer McCabe. This new fact about coming up, going to Michael Lank's house. It happened with Officer Sarah, coming up with a new determination about what was said or not said at the scene that we had never heard before. That was also a prep session of some sort, or I believe it was. And then this witness, literally, it's not even like just, was it light out or was it dark out? This is a completely new opinion based on evidence that we presented, both in or talked about in opening statement and have presented variously throughout this trial. And this officer gets on the stand and now has a new central opinion about whether or not we're right and that taillight lens could be cracked. That's something that should have at least been reduced to writing. And even if it was reduced to writing, it should have been excluded because it's a discovery violation. It's late. We don't have time to prepare for it, and we're caught off guard. I use the word at sidebar ambush, and I know that rankles the court, and the court doesn't like it, but that's exactly what it feels like.
Well, that's been used both ways here, right? So it's a word. Let's just take it out of here. Make your point. Okay.
I'll see if I can come up with a synonym for it.
Well, I understand your argument. So focus on, just continue where you were, but no comment whether I like ambush or don't like ambush. It's a word I've heard a lot on both sides.
I understand, Your Honor. My point is the evidence that now is being sought should never be presented in front of you. We didn't have opportunity to get this in advance. It's at least very least been in the Commonwealth's possession for weeks. He took notes about it. He now says, well, I didn't take notes about that specifically. I don't believe that as far as I can go. I think he did take notes about it. He was shown the video. He provided a new opinion. Mr. Lally knew that he was providing a new opinion. And then the first time he discloses this opinion is in front of the 16 jurors, 15 jurors. We would ask for its exclusion, Your Honor. And I'll submit.
All right, Mr. Lally.
Yes, Your Honor. As far as the pattern, especially coming from counsel, I simply find it laughable. As far as Officer Sarif, I think what counsel is referring to was testimony that was in his grand jury testimony. He was crossed about whether or not it was in his report, but it was in his grand jury testimony. As far as Ms. McCabe is concerned, that was regarding reciprocal discovery that was given to the Commonwealth weeks into trial by the defendant. It was then shown to a witness, which is perfectly permissible. Counsel asked a question of Ms. McCabe on cross, and she was aware of the material based on the late disclosure of reciprocal discovery. So there's no violation there. As it relates to and why I say laughable, Your Honor, is that I am still...
I don't like hearing you say laughable. Just
Understood.
Stick to what the arguments are. And
with respect to this witness...
Hold on. Quit the finger pointing, name calling, things like that, please.
Yes.
I know it's been a long week. It's been a particularly long day. But just focus on what you want to argue to me.
And I apologize to the court for that, Your Honor. With respect to this testimony, it's well within his realm as a crash reconstructionist. This is a witness who's responded to and investigated hundreds of crashes involving damage to vehicles. Simply making an observation of contact between two vehicles or purported contact between two vehicles on a video. The force is self-evident, and whether or not that force is sufficient to cause the damage that he personally observed on the defendant's vehicle is well within his expertise. And should be permissible as far as for this witness to be able to testify to.
What about the non-disclosure to the defense? Showing this video and asking for an opinion. What about that?
So, Your Honor, what I would say is I did not show this video and ask this opinion. This is a video that actually the trooper mentioned to me that he had seen over the course of while the case was pending, probably over a year ago, that he had seen that video. What I showed him was the photographs of Mr. O'Keefe's vehicle and asked whether or not he observed any damage consistent with the damage to the taillight observing or popping up on Mr. O'Keefe's vehicle.
Why wasn't that turned over?
In hindsight, it should have been, Your Honor.
All right. So it's late. I'm not ruling here. I want to review everything.
That was the end of testimony for the day. And I'm sure he will be back on the stand tomorrow for day 26. So with that, thank you so much for watching. Look forward to hearing your questions and comments. We'll see you back for trial day 26. Have a good night.